Good morning or afternoon, depending on where you're at. I'm glad you're here. My name is Carrie White, and I am your moderator for today. And today's webinar is Interpreting Depositions. We have a few housekeeping items we need to go through first. Captioning and interpreters are provided today. The streaming window opens automatically. There is a tab for the audio and video on the far right. Click on the bottom corner, and a menu will drop down. Click Detach Panel. Then you can resize the video box. To open the captioning, click on the captioning icon on the toolbar. Windows can be closed or sized to create your personal viewing environment. The chat window can be made bigger by pulling it out. To do this, click on the icon box in the upper right corner of the chat box to access the menu and make the chat font bigger. If you have technical issues, use the chat function and a member of the clearinghouse staff will aid you. Questions for the presenter will be in the chat function, and Carla will allow set up times, stop during the presentation and ask for your questions. So if she hasn't asked for your questions, please write them down and wait for Carla to ask for them. I'd like to also talk a few minutes about CEUs. On the conclusion of the webinar, when you exit out, a survey will populate. It's a satisfaction survey, and it will also ask you for your CEU information at that time. It can take up to 8 weeks for these kinds of events for the CEUs to be posted to your transcript, so please be patient with the process. It is tedious. I am checking on the length of time that people are logged into the webinar and comparing it to the CEU request list. So please stay for the entire webinar. Okay, with all that out of the way, I'd like to turn it over to Carla Mathers. Thank you, Carla.
Thank you, Carrie. And welcome, everyone. This is our 5th and final webinar in the 2013 summer series hosted by the Mid-America Regional Interpreter Education Center, the Murray Center. So I'd like to thank all of the staff there, Ann Witter-Marathu, the director, Lilani Johnson, Carrie White, Jesse Zhu, Lene Phillips, and all of the rest of the center staff. I'd also like to thank our interpreters today, Kirk and Terry. And my two typical disclaimers at the beginning are this presentation cannot constitute legal advice, can't be relied upon, and it does not create any attorney-client privilege. And secondly, most often depositions occur in the civil arena as opposed to criminal depositions. Depositions are defined as sworn testimony taken in a law office before an officer of the court, and they are used as evidence in a later proceeding. It's part of what we call discovery. And discovery is that part of a pretrial process where attorneys learn about their cases, each other's case. It's very limited in a criminal context, but it's quite extensive in the civil arena. Many times, a deposition will be recorded or videotaped. There are a number of reasons for that, but primarily to try to keep things more civil, because depositions can be quite unruly because they are unsupervised, meaning there is no judge present. And so the attorneys can at times get a little out of hand, and their approaches will vary. Often in the beginning, the attorney is going to be friendly and cooperative And the attorney taking the deposition wants the witness to ramble. And the attorney defending the deposition wants the witness to say as little as possible. So in the beginning, the attorney might be very friendly, trying to get the witness to volunteer information. Sometimes, when they're not getting what they want, they might become more aggressive and controlling. But that usually isn't the case, because you want the witness to talk. And so, if you think about a deposition, the court reporter is taking down what everyone says, both the questions and the answers and the objections. And you can't, and then a transcript is produced. So it's all written down. And just from reading the transcript, you can't get the mood necessarily. It becomes kind of sterile, and that's one of the major reasons to have a videotape, so that if an attorney or if a witness is uncooperative or hostile in some way, then you have that, and it makes a better impression on a jury to show the video as opposed to just reading a transcript into the record. Attorneys can derail depositions in a number of ways. I remember a deposition that my very important job was to count the number of seconds that the attorney used in making objections and making speeches, because in a federal lawsuit, depositions are limited to 7 hours each. So this attorney wanted to use as much of that 7 hours of him talking as opposed to letting us get the story from the witness. There was another deposition, pretty well-known case called Texaco Pennzoil a number of years ago, in which the lawyer's behavior was so horrendous that he was from Texas, but the deposition was in Delaware, and Delaware disbarred him because of his behavior in that deposition. Now, in a deposition, you'll also hear objections, but the objections at a deposition are very different than trial objections. In fact, almost anything can be asked in a deposition, except the only proper topic for an attorney to instruct a witness not to answer a question is if it relates to privilege. So you'll hear a lot of objections, but the witness is always instructed to go ahead and answer the question unless instructed by counsel not to answer the question on the basis of privilege. So primarily the purpose of a deposition is to gather information and to facilitate settlement. So I'll come back to those in more detail. But it's also used to perpetuate testimony. Civil cases can take years to complete. So after the incident that you're suing over, as soon as possible after that, you want to depose the witnesses so that you can get their story down and they can't then later change or say, I can't remember, because the length of time that passes between a deposition and actual trial can actually be years. So you want to perpetuate the testimony. There's a special kind of deposition called, it's Latin, it's called debeni esse, D-E-B-E-N-N, I'm sorry, D-E, second word, B-E-N-E, third word, esse, E-S-S-E. And it's a deposition in which the witness is not going to be available for trial later. So you actually have to take that deposition as if you were in a courtroom. So you still make your objections. They won't be ruled upon until later at trial. But it's a different kind of deposition because it's one in which the witness is not going to be available at trial to testify. And then to prepare dispositive motions. A dispositive motion is called a motion for summary judgment. And it essentially says, after this period of discovery, and after all your depositions have taken, after you know everything about the case, then you write a motion to the court saying there are no facts in dispute, we agree on all of the facts, and given that we agree on all the facts, the law is in my favor and I should win this case without having to go to trial. That's called a motion for summary judgment. So I want to spend a little bit more time on gathering information and facilitating settlement. This slide shows the parts of the discovery process. So a lawsuit is filed, you go to a scheduling conference. At the scheduling conference, dates are set forth in which the discovery process takes place. Interrogatories are written questions only between the plaintiff and the defendant, and they're answered under oath. At the same time you send interrogatories, you ask for documents. And you may also ask the other side to admit certain facts. And once you receive all of the documents and the answers to interrogatories and their admissions, then you create an outline for your deposition based on those documents. You can depose the parties in the case, and you can also depose non-parties, witnesses. The only difference is you send a witness a subpoena. And the vernacular you'll hear is that the attorney is noticing a deposition, and that means they're calling or convening a deposition, to notice a deposition. In personal injury cases, there are oftentimes requests for mental and physical examination. You may have interpreted in your experience where a deaf person goes to a doctor and the doctor isn't his doctor, but it's called an IME, which is an independent medical examination. Though it's not actually independent because the doctor works for the defendant. So the doctor's hired to essentially say the plaintiff's medical injuries are not as bad as they are presented in the lawsuit. Now, the information gathering stage is important because at that early stage in the process, the attorneys have only heard one side of the case. They only know their client's side. So they're still learning about the case. And it can be very enlightening to hear the other side. And that's why depositions happen early, and that's also why, as you're gathering information, you're analyzing the case to see the merits of it from your opponent. Which will help in determining whether or not there should be an early settlement. So at the deposition, you're going to be looking at the witnesses and evaluating their credibility. You'll also be looking at the other attorney and determining the strengths and weaknesses of not only the attorney as a lawyer, potentially a trial lawyer, but there's the strengths and weaknesses of their case. Plus, at that point, you may not have had much conversation with the other attorney, so you're opening lines of communication and kind of developing a rapport. There are times when depositions are called to actually just punish the witness. That's not the whole purpose of it, but that ends up happening if you have a witness who isn't very credible. And we had a client once who we found out such bad things about this man. It was a sexual harassment case, and we found out during the deposition, because the plaintiff had investigated him, that he had terrible, terrible things in his background. And we spent the majority of that deposition asserting the Fifth Amendment so that his words could not be used to prosecute him in a criminal matter. And then after that, when we had people who come to us to serve as their lawyer, in certain cases we started requiring that they take lie detector tests before, because you can't tell who's lying to you. And really the last place you want to hear about it is a deposition So let's talk a little bit about who is present at a deposition and what their functions are. So in a civil matter, both sides take depositions. So it's confusing to say plaintiff's attorney or defense attorney because they may take different roles depending upon who called the deposition. So the attorney asking the questions is called the deposing attorney. Generally, they'll just be the two attorneys, the deposing and the defending, but sometimes there'll be more. The witness, the person answering the questions, is called the deponent. And if the witness is a party, then they will have an attorney present called the defending attorney. If the witness is not a party, they may or may not have an independent attorney present. So there could be three attorneys there for non-party witnesses. Also, the parties are going to be there. Regardless of whether they're also a deponent, both the plaintiff and the defense are going to be present. There'll be a court reporter there. There may be an expert there, and an interpreter, obviously. A court interpreter will be there. There may be other people like experts there, because experts are permitted to form the basis of their opinion by watching witness testimony. And a deposition consists of witness testimony. So obviously the person missing is the judge. So there's no referee, and as I mentioned, that has tremendous consequences on the conduct of the proceeding. If there is a problem in terms of an objection or other matter related to the conduct of the deposition, they can actually stop the deposition and call a judge in chambers or a judge on call to handle the discovery dispute. But judges don't like discovery disputes. At times, you can halt the deposition and physically go to court. So if you're hired to interpret a deposition, you might actually find yourself in court if there's a problem with the deposition. So the deposing attorney also hires the court reporter, the videographer if there's one there, and the interpreter. So I might say this more than once, but it's important, very important to understand that it does not matter who is paying you or who hires you. Your role is determined by the function that you're interpreting. And in a deposition, you're interpreting witness testimony, which makes you a proceedings interpreter. The same thing with the court reporter. The court reporter is an officer of the court. At a deposition, they will be paid by the deposing attorney, but that does not affect their function. They are still sworn to actually accurately record the deposition. So I have a picture now to show you a deposition, and the deposition has a videographer. It has two proceedings interpreters, and also two table interpreters. The blue triangles are the proceedings interpreters. The green triangles are the table interpreters. The purple triangle was the deaf person, the deponent. The red oval is the deposing attorney. And the orange oval is the defending attorney. Then there is one camera focused on the witness, on the deposition. And next to that camera, not present, would be the court reporter. Then there's another camera focused on the proceedings interpreters. And so that's kind of an additional check because you have table interpreters there. So they're monitoring the proceedings interpreters. But we also had videographers so that the witness is on camera as well as the interpreters. In case there is an issue about the interpretation, the video can be watched immediately. So this is just one possible setup. There are many, many others. This is one that I did recently. So any questions about the setup? Any questions about anything we've talked about thus far? And I've been asked to identify the colors again, and I'm happy to do that. I will identify the colors, and then I will stop so you can take a look. So first look at the blue triangles, which are the proceedings interpreter. The green triangles are the table interpreters. The deponent is the purple triangle. The attorney asking the questions is the red oval. That's the deposing attorney. And the orange oval is the defending attorney. June asked whether or not this setup will work with the CDI, and it would work just fine with the CDI. And with a CDI, the CDI would be a blue triangle. Then the hearing interpreter working with the CDI would be somewhere between the purple triangle and the red oval. And Barbara asked, why is the deposing attorney out of the sightline of the proceedings interpreters? The deposing attorney is not out of the sightline of the proceedings interpreters. The deposing attorney is across the table and directly in front of the proceedings interpreters. The CDIs, someone asked again, Carl, where a CDI would be, and I just explained that. The blue triangles would stay, those would be the CDIs, and their teammate, who would be providing their source language, would be across the table, probably where that camera is. And Barbara said, I mean, the deponent cannot see who's talking. That's a good point. In the actual deposition, the room was small enough that everybody could see everything. The most difficult thing for this particular deposition was the table interpreter on the defending side had to keep asking the attorney to back up so that she could see the proceedings interpreters. There was no other good way to do it. Natalie asked, what are the responsibilities of the table interpreters and why are there two? There are two because in this case, the witness and the attorney had to talk to each other, so the red oval with the table interpreter next to them also interpreted conversations between that attorney and the witness. And then the defending attorney had an interest in ensuring the accuracy of the interpretation, so he hired a table interpreter to make sure it was accurate, although he didn't have any privileged communications with any witness. Okay, so the room is really going to constrain how you set up. Clearly, it would have been better to have the blue triangles near the red oval so that the deaf person could actually look at the attorney who was asking questions. And again, I haven't quite said this yet, but it's not the deposing attorney asks questions, and then the defending attorney can also ask questions. So it's not really direct and cross-examination. It's more like direct and then clarification. So that if the witness says something that the attorney wants clarified, they can do that on their turn. Sergio has asked, can the recording of the interpretation be challenged? And so who would check the accuracy? The interpretation can be challenged. The table interpreters would make their case for whether the interpretation was accurate or not accurate. And because it's a deposition, nobody would make the decision right then and there. But the transcript would have the explanations, and if that portion needed to be used at trial, then at trial the judge would make that determination. And Judith asked, do courts or attorneys ever balk at hiring 4 interpreters for 1 deaf person? Seems it might be hard to convince them. In a deposition, the deposing attorney has hired 3 interpreters, and the defending attorney has hired their own table interpreter. In court, the court would hire the proceedings interpreters too, and the attorneys would pay for their own table interpreters. So the court's not being asked to hire 4. And yes, attorneys do balk at paying for interpreters. There are very important reasons for having a table interpreter present. And in my opinion, it's more important to have a table interpreter present than it is to have a videotape, because you have to object immediately to any error in the interpretation in order to preserve it for appeal. And if you don't have a table interpreter present, but you have a video, and you take the video to your expert a week or so later, it's too late to object immediately. Now that's more for a court during that proceeding than a deposition. And I'm looking at Deborah's question. If a CDI is involved as a proceedings interpreter, does that mean one of the table interpreters needs to be a CDI as well? That's a good question. And it certainly would be the case if the opponent used a CDI, then the table interpreter for the witness, for whatever side was sponsoring that witness, may very well have a CDI. Again, it depends upon the reasons why a CDI is indicated for the deposition. If it's because it's a high-stress witness testimony, but the deaf person still uses American Sign Language or some variation thereof, then maybe you don't need a CDI for the table work, since that's relatively low stress and it happens in a private room outside of the deposition room. But it just depends. I know that a number of friends of mine who are CDIs have functioned as table interpreters. All right, so again, there's lots of different ways to do it. Often, as with much of what we do, the problem is sightlines. The problem is figuring out where not only you can be in a small room, but also where the reporter's going to be and where the cameras are going to be and all of that. So I want to talk just a little bit now about the process of what happens in a deposition. And I think that's important for interpreters because you can use, once you understand the process, you can use this information to predict. If you understand the discourse style of the attorneys and why they're doing what they're doing, that helps you in accurately interpreting and predicting what is coming next. So in the beginning of a deposition, the reporter starts, and the reporter will swear the deponent. If there's an interpreter present, they'll swear the interpreter first. At that time, if the interpreter has disclosures, that's when they should be put on the record. You might hear attorneys talking about the usual stipulations. They're referring to the ability to object without having to follow the formal rules of evidence at trial. And that's really it's rather old-fashioned because the rules of evidence have been changed to dictate how objections are handled during depositions. So you don't need to agree that if you don't make an objection immediately, you can't bring it up later at trial because the rules of evidence already say that you can. Another stipulation is, and you'll hear them say, what about reading and signing? And what reading and signing means is once the transcript is prepared, it's sent to the attorney for the deponent. And the deponent has the opportunity to read it to make sure that the court reporter didn't make any errors in transcribing their testimony. The purpose of reading is not to read it and change your answers. That's not permitted. Only errors due to the court reporter or the interpreter can be changed, and they're listed on what's called an errata sheet. Once all the errors are listed out, then the deponent signs the errata sheet or signs the deposition transcript, and it's done. So that happens at the beginning of the deposition. Then they start asking questions, and in the beginning you have to set up these commitments. Let me give you an example of what they look like. You'll hear this in every single deposition that you interpret. So the commitments are done to ensure that the witness can't go back later and change their answers. It'll sound like this. My name's Carla Mathers. I represent so-and-so. I'm going to ask you some questions about the facts that gave rise to this lawsuit. But first, I want to set some ground rules. If I'm unclear, please tell me immediately. If you do not understand a question, please don't answer it, but ask me to clarify. If you can't hear me, please let me know. Ask me to speak louder. If you want to change an answer, that's fine. Just let me know. If you need a break, it's fine to take a break. I ask you not to ask for a break while there's a question pending. But once you give the answer, I'm happy to take breaks. And then I ask whether or not you are under the influence of any alcohol or medication that might interfere with your ability to give truthful answers. Is there any reason at all that you'd be unable to recall the events that started the lawsuit? Is there any reason why you shouldn't be deposed today? And that establishes the attorney's fallback position so that the witness can't later say, but, oh, I didn't really mean that because I was on medication, or I didn't really understand that question, so I just answered it the best I could. So those are the commitments. So, and witnesses are also prepared by their attorneys, too, as to how to answer questions. In particular, they're told not to volunteer information, to answer just the question that's been asked, and the same kinds of commitments. Don't answer a question you don't understand or you can't hear or anything like that. So then for the bulk of the deposition, there are these various questioning styles so that go through each topic that you're being asked about, or that the deponent's being asked about. And it looks like this. So in the beginning, there's this open questioning phase. It says, why does direct examination? Someone that you understand and you trust that they'll give you honest answers. So you're asking all the reporter's questions. What happened? Who was there? When did this happen? How? And then you go into a clarification phase after you've gotten some information. You go back as the attorney and you kind of flesh out the various responses that were given. And then to close the topic, you have to be, and I'll give you some examples of this, but you close it off so that there's no possible way that the deponent can come back later and say, but you didn't ask me this, or you didn't ask me that. So you're trying to exhaust their entire memory of that particular topic. So first, some examples of the open phase. Right, so you're getting the general gist of it. In the clarification phase, I'm going to go back and look at each of the topics and try to pin the witness down as to their memory of each of these particular topics. Once you've clarified, as the attorney, once you've clarified the various issues in that particular topic, then you want to close off. So depending upon the topic, it might sound like, were there any other meetings? Did they say anything else? Is there anything else you can remember? Were there any other people present? I mean, it sounds silly sometimes, but the structure is really quite important so that this witness can't come back and say, well, I remembered that later, because it looks fishy given that the deposition happened so close in time to the events and trial is much later that they couldn't remember at the deposition but somehow miraculously have now remembered later. So knowing the discourse helps you as an interpreter because you can anticipate the kinds of interpretation you're going to be doing, and you can anticipate when a topic is opening, when it's in the middle and things are getting fleshed out, and when it's closing and we're moving on to another topic. Any questions about the kind of structure of the deposition, what happens, before we go into talking about the role of the deposition interpreter? The deposition interpreter, again, is a proceedings interpreter, and that's because the function that you're interpreting is witness testimony. That means all of the rules and standard practices that apply in court apply in a deposition. You're still an officer of the court. Your duty is to the integrity of the interpretation, not to the attorney who hired you. But you're affiliated with the court. You're still guided by the court interpreter code of conduct. And that means you have to be careful about being borrowed to interpret privileged communications. Now, a way to avoid that is to do adequate preparation. By that I mean when you're hired, you call the attorney and you say, how are you going to interpret, how are you going to handle privileged communication? How are you going to handle objecting to the errors in the interpretation and advocating for a table interpreter to be provided by the court? Otherwise, the attorney is going to do exactly what they do in court and expect you to do the privileged interpretation for them. I'm just glancing over at the box, and Helene has asked whether consecutive interpretation is preferred. The same rules apply in court as do in depositions, and so a deponent is a witness and is giving testimony. Therefore, we know that we use consecutive interpretation. So protocol issues are the same as well. And by that, I mean, for example, how we speak for the record in the third person, that kind of thing. I did a deposition once of a deaf plaintiff, and I was his attorney. And there was another attorney on the matter with me who we could both sign. And so we didn't have a table interpreter with us, but we had very good interpreters. And so if there was a need for any monitoring, we would have done it. And the deposition was on video, and it was the class action case. So the plaintiffs were from all over the country, and the interpreters were from Washington, D.C. So when a plaintiff came in, it was likely that they would be using some either signs or referring to towns and cities that the interpreter was not familiar with. So during the deposition, the interpreter quite properly would speak in the third person and ask for clarification, ask counsel to permit clarification when she needed clarification of a particular sign, which was fine. And that went on through the deposition, and then during a break, she talked to us and said, I feel kind of funny doing this because you can understand me, and so maybe if you wouldn't mind giving me permission, I can just inquire directly of the deaf deponent when I needed clarification or a repetition. And we were fine with that. And so when we went back on the record, neither of us thought to make a record of what that conversation looked like or what had happened while we were off the record. And so thinking back on that, if you look at that particular videotape, you have an interpreter who's using proper protocol for court interpreting all the way for the first couple of hours or so. And then all of a sudden, when you're looking at the transcript or at the video transcript, she stops and she starts directly talking with the witness when she needs clarification. So we talked about that and thought, gosh, we really shouldn't have done that, or we should have at least made a record so that it was on the transcript exactly what we had agreed to, the stipulation that we'd agreed to with the interpreter. So that's just a point of clarification. You can suggest that the deposition is videotaped. I have no problem with that. Again, I think it's more important to have a table interpreter present for immediate objection. But if you can get it videoed, then that's great too, because you can look at the video to see what the witness actually said. One other thing about the court code and protocol, you've got to make sure that you do put any conflicts of interest on the record prior to taking the oath. So any prior interpreting that you've done for the parties that will not affect your interpreting during the deposition need to be noted. So I'm going to try something based on your feedback. I'm going to give you a scenario, and in the chat box we're going to talk about what we would think about the scenario and what are the possible options for the interpreter, and try to make this just a tad bit more interactive. I'm going to read the scenario, and I'll read it more than once, and then I'd like to get your thoughts on it. So here it is. You arrive at the deposition, and the attorney wants you to interpret a private conversation between the witness and her attorney prior to beginning the deposition. You'd have a team interpreter for the deposition, but the defendant or this attorney has not thought to hire their own interpreter for the conversation. What shall you do? So here's the scenario again. You arrive at the deposition, and the attorney wants you to interpret a private conversation between her and the deponent prior to starting the deposition. You have a team, but there is no table interpreter, so what do you do, if anything? I see Brenda saying you can't do it. The perception could be misconstrued by the court. Suzanne says you explain the role and function of each interpreter prior to starting. Helene, okay. Disclose, then put on record and extend the privilege. Michelle says if you are the proceedings interpreter, you should not interpret it. Brenda, kindly explain and reschedule the deposition. Christine, get consent from all the interpreters on the record to borrow the interpreter. Janice, explain the role and responsibility. Several people are saying the same thing. Joy has an interesting idea. One idea might be to suggest VRI be used for the private conversations, but it would have to be available, and people would have to have equipment. Great. I'm not sure I need to read everybody's comments because we're all reading the same chat box. But I think we come to the central dilemma here is that the interpreter hasn't prepared in advance by talking to the attorneys and explaining role, as everyone said, and suggesting that they hire the interpreter. But also, folks have some really good suggestions to make sure that if borrowing is done, that it's put on the record and that everyone has agreed to it and knows that it's happening. I think it also depends on exactly what they want to talk to the witness about. You see, attorneys, once a deposition is started, attorneys are not permitted to talk to a witness about their testimony. Same thing in court. Once a witness is sworn, attorneys are not able to talk to the witness about their testimony. Now, I noted in the scenario that this was prior to court, but I think as an interpreter, once you explain the difficulty and the dilemma, I would also find out exactly what they want to talk to the witness about. If it's going to be about their testimony for the day, then I would let the attorney know that that's not proper, but if they want to receive a stipulation from opposing counsel, then put it on the record. You as the interpreter should make that particular record, not depend upon the attorney to do it. Right. So, at that moment, you're in a really bad place, but I think that you're also working within the system, and you don't want to cause them to have to cancel the deposition or reschedule the deposition because it's very, very costly to do a deposition, and in part it's because the interpreter didn't prepare well enough by finding out whether or not there would be a table interpreter there. Okay, so good discussion. That wasn't as difficult as I thought it might be. So I'm going to give you a harder one. And I will read this a number of times. Think in listening to it, think about the role and function of interpreters. So 2 interpreters have been hired by a deaf plaintiff, by the plaintiff's attorney, for in-office preparation for the deposition. So they had an all-day session. The lawyers hired 2 interpreters to interpret the prep for their deponent. And then during the actual deposition, only 1 table interpreter was present to monitor. You didn't need 2. Now, the following week, there's a defense witness, the other side, who's hearing, and they're giving their testimony, and the plaintiff, who is deaf, wants to attend. Okay, so next week we have another deposition. It's a hearing witness, but the plaintiff is deaf and the plaintiff wants to attend. So it's an all-day deposition, so the plaintiff wants the 2 law office interpreters, table interpreters, who had interpreted for their preparation, wants those 2 interpreters to attend the deposition of the hearing witness and interpret for the deaf plaintiff. What are your thoughts? Catherine asks, is the witness there for the deaf person's side of the case? No, it's the other side. Okay, before we go ahead, I will repeat the scenario one more time, but I also have a number of comments. I want to get to them. The scenario is that 2 law office interpreters, so they are table interpreters, interpreted for an all-day preparation session for the plaintiff's deposition. The plaintiff is deaf. They did that in the law office. Then during the plaintiff's deposition, only 1 was present as a table interpreter. Now, a week later, the defense has a hearing witness they will be deposing. And the plaintiff wants to attend and wants to use the same 2 interpreters that they have been using at their table. And Margaret says, at first glance, it seems to me you are still a table interpreter. I would definitely agree with that. Bethany says, I would think that the interpreters would be PIs and unable to go back to any table interpreting services. Actually, you can go back. You can't go the other way. So you can go from proceedings work to table work, but then there's the question about whether you can go from table work to proceedings work. I see no, the TI function will then taint the interpretation. Suzanne says it's okay if you put it on the record. Catherine says, is the plaintiff allowed to speak other than to his or her attorney? That's a very good question, Catherine. No, the plaintiff would be there as an observer only. They may talk to their attorney on breaks, but they don't have any role in speaking during the deposition. Gail says if the interpreters are hired by the deaf defendants, they are working as table interpreters for the complainant, so they are not proceedings interpreters. They are not hired. Let's see, if the interpreters are hired by deaf complainants, yes. They are working as table interpreters, yes. So they are not proceedings interpreters. Correct. They would not be sworn, for the record, because they're not interpreting any witness testimony for the record. So New Jersey calls it record interpreting. That's not what they're doing. It's more like they are doing a proceedings function, yes. If they were in court and the hearing witness was in court, they would be court interpreters. But we're not in court. We're in a deposition. And Rachel says plaintiff is there just to listen, so there will be no input from the plaintiff, therefore it won't be a bleed situation. I agree. We wouldn't allow this in court, but I think the nature of a deposition is somewhat different. Certainly the deposing attorney in this scenario has no obligation to hire an interpreter. So the interpreter would be provided by the attorney who has a deaf client. So, and the fact that they won't be interpreting anything for the record, I think, suggests that it's more proper to, that it's permitted to use them. And I understand Larry's point that the interpretation may be tainted from what was learned in the deposition, which is true if they were interpreting in court on the record. But they aren't interpreting anything for the record during this particular scenario. Several people have asked who hired the interpreters. The interpreter was hired by the attorney who has a deaf client. I'm not going to read them all. I'm going to pick out some questions or comments that have points that we haven't discussed yet. And Liz has talked about it being that, or it seems that these interpreters would be more like an ADA accommodation, not actual PIs. And I tend to agree with that as well. They aren't sworn during the deposition, and they do no record interpreting. They're simply there to let an audience member see what is happening in the deposition. And Margaret says, I would think that you function as a TI and maintain that role during the deposition of a hearing witness, and then be able to return as the table interpreter for that side. That's exactly what happened here. Right. And Sergio says if this was a spoken language interpretation, the table interpreters can whisper, and though there are no problems, therefore no problems, and it could be done without having it on the record. Right. Right. The recipient of the interpretation is the deaf audience member, plaintiff, for lack of a better term. Right. Not the reporter is not receiving the interpretation in order to create a transcript of the record. And Larry asks, what if the deaf defendant wants the same interpreters in court? The only place that those interpreters can function in court would be as the table interpreters. Bethany asks, wouldn't it be the responsibility of the court to provide access to an observer? Why is the attorney hiring interpreters? In court, the court would have the obligation to provide access to audience members. A deposition is not in court. It is part of the pretrial discovery process, and the attorneys pay for all the costs. And the costs include court reporters' fees. They include the cost of creating the transcript, a videographer, interpreters. That's just the way the court has always been that way. It would be impractical, impossible, and extremely expensive for courts to have to pay for all of the discovery that litigants in America go through each year. Okay, we've already talked about the monitor, but just as a refresher, at a deposition there can always be a table interpreter. It goes by many different names: the monitor, law office interpreter, consulting interpreter, an expert. We hear lots of different ways, but the definition is essentially to interpret all privileged communications and to monitor the proceedings interpreters for accuracy, to assist the proceedings interpreters in a limited fashion with their preparation. And again, the process at a deposition is a little bit different because it's not, when you're monitoring, there's no judge there to make that decision, but you do have a transcript to consider. So the monitor or the table interpreter, when they address an issue, they will be speaking to the transcript, in essence, keeping in mind that they have that transcript and that their statements will be preserved. The monitor should also have a process in place for with the attorney for how they will let the attorney know when there have been errors, what that process looks like, whether it's a whisper, whether it's written, whether the monitor I've seen can just go ahead and stop the process and say there's an interpretation error or issue that needs to be addressed. The range of options is the same as with monitoring at a trial. You just have to talk to the attorney about them. You also can talk to and should talk to the proceedings interpreter because the table interpreter knows the story and the proceedings interpreters don't. So in terms of linguistically, if there are issues that the table interpreter knows that are going to be come up during trial, they can certainly share linguistic information with the table interpreters or with the proceedings interpreters. I've seen some attorneys who want the discussion between the table interpreters and the proceedings interpreters on the record. So that shouldn't be a problem, and you should be willing to make public or transparent that discussion that you're having with the proceedings interpreter. And ask if you can share name signs. Yes, that's a completely proper thing to do, is to share name signs. Questions about the monitor or the table interpreter at all, and their role and function in a deposition as vis-a-vis regular court proceedings? Okay, so the final area that I want to talk about is how you prepare for a deposition. And I've already talked in some detail about the obligation to contact the attorney ahead of time, find out how they've been communicating with their client, to find out what they intend to do, when during the deposition. And not the final thing, but I think one of the key points that you can make to convince an attorney to hire their own interpreter is to talk about that contemporaneous objection rule. And if you recall, that is when an error is made by the proceedings interpreter, the attorney has to object immediately, or they do not preserve that issue for review, for appeal. So that's really important. I see that Jenna is asking for an example of language that might be used when a table interpreter sees an error. Language for the record, or language, I assume that you mean language for the record and not what you talk to the attorney about. So if I noticed an error, I would let the attorney know that there's an error that needs to be discussed. And then I would say, for the record, the witness used the sign red and the interpretation was rendered as blue. Then the burden of proof still is on me as the table interpreter, so it would then the proceedings interpreters would have an opportunity to respond and either stand by their interpretation or stand corrected. And because there's no one there to make a decision, it often is left like that. Or you can suggest that the witness be asked to repeat their statement so that there can be another check. Or if there's a videotape, then the videotape can be rewound and everyone can take another look at it. I think that most proceedings interpreters want to do an accurate and ethical interpretation, and so they appreciate the opportunity to correct their interpretation if they have if an error has been brought to their attention. And I saw a couple other questions I'm going to go ahead and see if we can respond to. Veronica has asked whether or not the table interpreters or the proceedings interpreters watched the video transcript afterwards, and if they find errors then, how do they rectify them? I've never shared a deposition video with the working interpreter, and so I'm not entirely sure. I do know that when interpreters are subpoenaed to testify about work, usually in a criminal context, and that work has been videotaped, and then I always tell them to contact the prosecutor, who typically has the video in their possession, and make an appointment to go view it to make sure if there are errors, they can be discussed in terms of the decisions behind them, so that the prosecutor wants to know exactly where the errors were and why they were made. Haven't seen that in the civil context, though, only seen it in the criminal context. Margaret's asking about the rules of evidence changing. Can an attorney hire an interpreter later and object based on the interpreter's observations, or did I misunderstand the rules of evidence? No, you understood what I said. At trial, it's you snooze, you lose, right? You have to make that objection to preservative appeal. That's not always the case at depositions because the rules of evidence have changed. So it may be that an attorney who failed to have a table interpreter then had the interpretation reviewed on video and tried to file a motion or to create an issue for appeal at trial. I haven't ever seen that happen, but what I know about the rules of evidence are you don't actually waive your right to object unless, there's a couple of different variations. One is unless it can be fixed immediately. If you don't object to something that can be fixed immediately, then you really, I've seen them say you can't object later. So it may be in this instance that if you don't have a table interpreter present but you have a video, that you can try to make an appealable issue at a trial. The preparation is, Suzanne has asked whether or not the preparation is done on the same day as the deposition, like half hour before. When I'm hired for a deposition, I have a couple of standard things that I ask for immediately. I want to see a copy of the complaint, and I want to see the witness list. That's for a trial. For a deposition, I want to know who the witness is to make sure I don't have any conflicts of interest. So it's relatively easy these days with technology to get those things at the time that you're hired. So I do start well before the day of the deposition. In terms of this kind of preparation, talking with the attorneys, I'll go through each of these, but much of this happens at the deposition prior to starting the case, which is another reason why I may not want to be available to interpret for the attorney, given that I have my own preparation that I need to handle. Okay. I'm going to go ahead and finish this slide, and then I'll come back and address the rest of the questions. So preparation for the deposition interpreter involves talking to the attorneys and the deaf person separately. So with the attorneys, you need to know what the case is about, just like we do in court. I will have had the complaint ahead of time, as I mentioned, and I may have questions about certain aspects of the complaint or some of the facts that the complaint is describing. I'd want to know the deponent's role, whether they're a witness, non-witness, party or a non-party. I want to know if they're the plaintiff or the defendant, obviously. With the deaf person, we do the same spiel as we do in other legal settings. So you talk about consecutive interpreting, you talk about note-taking, you talk about everything will be interpreted, you talk about when I speak for the record or speak for myself, that will not be interpreted, which is one of the questions somebody just had. When the table interpreter is addressing issues with the deposition interpreter, nobody's actually interpreting that. It doesn't mean that the attorney can't, once that's done, the attorney can summarize what was just said, so that can be interpreted. And we have to do that establishing communication thing, which usually isn't a problem. Then you also meet with the other interpreters, and I've already talked a little bit about this, but to share that linguistic information, locations, name signs, parties, their roles, with respect to linguistic information that may have been set up or used by the table interpreter during the privilege or the preparation settings. Context, you might need specific information for consistency. How big was that bag of cocaine, kind of thing. You talk to the other interpreter about whatever, you talk to the proceedings interpreters about whatever system you set up for interrupting the proceedings. And a reminder about consecutive interpreting and protocol and disclosures. Then there's documentary preparation. If you have time, you'll have the complaint ahead of time, but you may also want to review the answer or any answers to interrogatories or exhibits. If the attorney is going to be using exhibits, you want to see them, particularly if it's not just paper exhibits. You may also want to have a conversation with the court reporter, because you may need to remind him or her that you need to be sworn. You may have brought a copy of the oath with you. And I let the reporter know when I do have disclosures to make that I will be making them and when I will be making them. And sometimes it's helpful to talk to the reporter or ask the reporter how they're going to indicate when the interpreter is talking in the transcript, because they need to identify when the interpreter is talking versus when the attorneys or the witness is talking. But essentially, preparation for a deposition is just like you would be preparing for any witness testimony. It just is a little bit different because it's in a law office, it's at a pretrial stage, and there's no judge there. Now, I'm just going to take any last questions that anyone may have. And I'm reading Joy Thomason. She says, for clarification, if an error is noticed by the table interpreter, does the attorney make a comment for the record, or is the TI sworn in and make a comment? It's a very good question. If you are ever sworn in as a table interpreter, it would be as a witness, not as an interpreter. And it would be at the time most likely that this happens. Well, it could be at the beginning too. But we don't want to let the attorney make that record, because the table interpreter is the expert. They're the ones who, hang on one second. Sorry, I was losing my voice. You're the expert. You're the one who knows how to talk about our field. So we want to make sure that the record is very clear. So I don't want the attorney trying to explain the error. I want to do that as a table interpreter myself. And I have had, excuse me, I've had one deposition where I, as an interpreter, was sworn. And it was very strange proceeding because they swore me as an interpreter. And I made a record that I would be happy to take a witness oath. But since I was not interpreting any of the proceedings and simply monitoring, I did not think it appropriate to take a witness oath. And they said, essentially, we don't care. So I took the oath and then monitored. But I would suggest that you can take a witness oath to tell the truth as to what you're monitoring and any errors that you identified. And I guess probably for consistency it should be done at the beginning, but if it doesn't, then it will be at this moment, as you mentioned. Natalie mentioned that copies of interrogatories are helpful to get ahead of time. I go one step further because you have a choice between interrogatories and answers to interrogatories. And answers to interrogatories replicate the question and the response. So if you do have a chance to review the file, it can be very helpful to see both the questions and the response. And so if you're you're talking to an attorney, ask to see answers to interrogatories, and that'll automatically get you the questions. Suzanne has asked whether this slide preparation applies to both proceedings interpreters and table interpreters. This slide, except for the last bullet, applies to proceedings interpreters. Right, so the final slide is you meet with the other interpreters, meaning the table interpreters. Christine's asked me to repeat what I said about knowing the deponent's role. Sure. I want to know if they're the plaintiff, the defendant, or a witness, a non-party witness. And I want to know I should know this, but I want to know which side they support. Typically, they're going to be the defending attorney. It will be their client or their witness being deposed by the other side. So the deposition is noticed by the attorney who is against the witness, for lack of a better way to say it. Jessica has asked how long are depositions? That depends. In federal court, we're limited to 7 hours, but frequently when interpreters are used, the attorneys will file a motion asking for more time, saying that the process of interpretation artificially extends the time. So certainly in our federal case that we did with all of the plaintiffs in the class action, each deposition was specifically agreed to be 2 7-hour days. And Sergio's asked whether or not debriefing is allowed during the break between a table interpreter and a proceedings interpreter. And certainly, you can, as long as you have stipulation with respect to the debrief on the record. And again, some attorneys are going to want you to do the debrief on the record. I did a deposition, the one I showed you the picture of, with the 2 table interpreters. And in the beginning, we didn't think we needed necessarily to meet or to talk, but as the deposition went on, it became very difficult to interpret. And so we did ask for a short meeting, and we got it on the record and asked them if they wanted to be present, the attorneys, and they didn't. So then we took that conversation into another room so that we weren't standing in front of a deaf person having a conversation. And Jenna has suggested that attorneys often try to hire one interpreter for a deposition since they say it will be short, and wants to know whether we can confirm all assignments on the record should have a team, regardless of the length of the deposition. Personally, I work as a team always in a deposition. I try always to work as a team in trials for witness testimony as well. I don't always get what I want, and that's just because of the courts where I work. But yes, a team is required for deposition. I'm reading Brenda's comment. I'm not going to repeat it because you can read it, but I will suggest that that experience would probably change dramatically if you were using consecutive interpretation. Margaret has asked, is there a difference in discourse style as compared to cross-examination, and where is a good place to observe and study that style? There is a huge difference. Deposition discourse style is much more like direct examination. Remember, we're talking about the WH questions. Very little cross-examination will happen in a deposition. So from an interpretation perspective, that means on direct and in a deposition, the majority of what you will be doing is ASL to English interpretation. Whereas we know in cross-examination, our focus is on English to ASL because the critical information is in the question and the responses are short and directed. They're leading questions, so the answers are yes, no. That has a huge effect on how we predict what we're going to be interpreting in a deposition. I do want to say that when I have done hundreds of depositions, and I would, as a defendant, when I represented the defense, I would not do cross-examination per se, but if I knew that I was going to be writing a motion for summary judgment, then I would try to get the witness on my cross-examination. I would try to get the witness to agree to those facts that I needed in order to write my motion for summary judgment and tell the court, look, we don't disagree on the facts, and even if you believe everything the plaintiff says is true, I still win because the law is so heavily favors my side of the case. There's no question. So, but most attorneys don't do any. It's primarily, it's always just the plaintiff's attorney. The deposing attorney does all of their examination and turns it over to the defending attorney, and almost always they say, I have no questions. They'll typically go back and clean stuff up, but I would do it when I knew I had a motion coming and I needed specific admissions. So a good place to see that kind of thing is probably just courtroom testimony, or I know that there are a number of depositions on YouTube that you could look at. Natalie has two IME-related questions. Remember, an IME was the independent medical examination in a personal injury case. I'm not entirely sure if it's the doctor who pays for the interpreter or the attorney who pays for the interpreter. I did have an opportunity to interpret an IME within the last year, but I was sent by my office, and I don't remember, or I don't know that they told me who was paying for it. And secondly, if I interpret an IME, I have interpreted part of the investigation. Therefore, I am excluded from doing the proceedings work, correct? Yes, correct. That's part of the investigation. Again, our hearsay rules apply. The IME cannot testify because the IME doesn't have personal knowledge of what the deaf patient said. In order to get the testimony in, if the attorneys are following the rules of evidence, they would need to call the interpreter from the IME to authenticate in order for the doctor to give an opinion. Okay, Rachel has piped in and said that the IME is usually paid for by the insurance company, who also pays for the interpreter. So that's a good example of us using our collective knowledge to understand a little bit more of this kind of complicated area of law. I know that we have 5 minutes left, and I know that Carrie has some closing remarks that she wants to to give to you. So I'm going to show you just this final slide. If you are interested in more in-depth legal training, please know that the Do It Center has an 18-month legal interpreter training program. It's a 4-course program. Some of you on this webinar today have gone through the program, and some of you are in the program as we speak. So if you want more information on it, you can go to the Marie Center's website, and you may also see the archived sessions. And Carolyn's going to talk to you some more about the CEUs. I appreciate your attention, and it's been a very interesting ride for these 5 summer series webinars that that Anna really put together. So thank you very much for having me, and Carrie, she's all yours.
Thank you very much, Carla. I'd also like to thank our collaboration partner, the Katie Center, and our interpreters, Kirk and Terry, our captionist, Carol, and of course, the Clearinghouse, Jesse, and her team. I want to remind you that CEUs can be requested by completing the CEU request form, which will appear after the satisfaction survey is completed. The survey will open up once you close out of the webinar software. Submit the survey, and you will see a screen where you can click on the form to request CEUs. This form must be filled out to receive CEUs. If the survey does not pop up, please email me and I will send it to you. Also, if the survey doesn't come up, you can also go to the web page for the webinar that was provided to you in the email. And there is the link to access the webinar tonight, and you'll see this link for the survey there at the bottom of the page. A group sign-in sheet was attached to the email that was sent to you. If you watched in a group, not individually, but in a group, please have everyone sign in and then email the form to me. CEUs can be awarded via the sign-in sheet or the survey. I encourage everyone, though, to complete the survey even if you use the sign-in sheet. There is a listserv that will be open up for 2 more weeks. I will send out an email tomorrow, well, Monday, on the webinar interest list. If you want to join our webinar interest list, please visit the Marie website. And I think that is all. And if you sign up for our webinar interest, you will get more promotions on future webinars. Thank you very much. Have a good day.